How are businesses most frequently discovered as violating the state's independent contractor rule? And what agency is most frequently auditing our businesses?
So one of the big ways that this issue becomes relevant is in the context of wage and hour. And there are several important cases that are actually pending right now, both in New Jersey and in New York, that may very well have important outcomes for your members. Because in Westchester right now, there's a federal court case pending. So in the case that's pending out in Westchester in the federal court, that case, in the event that the golf club loses that case, that could have significant impacts on the industry because there are a number of issues. One is classification and whether golf caddies should properly be classified as independent contractors or employees, at least in that particular case. And also the issue of how caddies can be compensated and whether receiving bag fees and tips is sufficient as wages. And depending on how the members here compensate the individuals working for them, particularly in this case, the caddies, this could substantially impact the way in which they do business. And, everyone should be aware that there are law firms out there, including the plaintiff's firm that is litigating one of the cases that Tom was talking about in New Jersey, that they advertise specifically for caddies. They're out there sort of like, the old-fashioned ambulance chasers in the personal injury world. We have people like that, plaintiffs' lawyers in the employment world, where they find a hook and they seek out these kinds of cases. So here, this particular law firm is actually seeking golf caddies who believe they were not paid properly. So they have a webpage about this, seeking individuals to bring lawsuits against the company that engages them or employs them. So it's definitely a timely, important topic, and golf courses, clubs need to really look at how they're compensating people and what sort of support they have for whatever classification and decisions they're making to at least show the good faith effort to be compliant.
Yeah, I think one of the interesting things in the case that Kim has referenced a couple times in Westchester is the golf club there is, for purposes of a motion to dismiss at the beginning of the case, is conceding that the caddies were employees and basically saying that, the bag fee and the tips were sufficient to cover the wages. They don't even really want to get to the issue that would potentially open the floodgates of the court deciding employee versus independent contractor. They're trying to kind of get out in front of it at the beginning of the case. Whereas the other case in the state of New Jersey, that seems to be, the main focus point is whether or not the caddies are employees or independent contractors. And I see on the docket that the case is heading to a settlement conference in June. So it seems that, both sides want to resolve this maybe without the court having to decide, because either way it could hurt, the plaintiff side or it could hurt the club side. So, even the first case that we found from back in 2019 involving a club out in Southampton here on Long Island, that case also settled after a mediation to avoid the court having to make the ultimate determination that could have, as Kim noted, really wide-ranging impacts on clubs.